Hi, my name is Tori McMillan, and I'm a resident. I just have 3 questions. The first is that it seems like the permits are issued on the basis of rules, which makes a lot of sense, but you also are taking public comment, and it's unclear to me what role public comment actually plays in the permitting process. So are they issued based solely on rules, or how does the public comment get incorporated in? So maybe I'll do one question at a time.
That's a good question. That's a question we've been asked a number of times. You're correct. We're duty bound to use the rules as a guideline, as a basis for reviewing the permit application and rendering a decision. The rules do require that, and actually, technically for this particular application, public hearing is not required, but we're holding both an information meeting and a hearing because we know there's a lot of interest and we want to take comment. We do take public comments and the information that we receive from the public into consideration. I guess the best way to answer your question is, to the extent that public comment addresses how the application does or does not meet the standards for issuing a permit, the rules, those are the most effective public comments that we receive. Those are the ones that help to guide us to make an appropriate decision. Having said that, what we hear in toto is of value and it's important. And it's hard for me to give you a, someone said, "Oh, it's not a referendum," and it's true. We don't just take a vote and say, "Well, whoever gets the most votes, the permit is denied or not." We do have to use the rules, and that's what we do. But I think that having taken a lot of public comment on a number of different applications, on a number of different topics, it matters a lot, and not always necessarily whether we get to a yes or a no, but in the event that we get to a yes on a particular application, public comment has frequently influenced what that yes looks like. A simple example of that would be, let's say, a transfer station permit. And we go to hearing, and lots of folks are concerned about truck traffic and how it's going to queue up in their neighborhood. And there are many cases, and Mike could probably talk about them, where we've listened to those comments and we have amended the permit, or what was proposed in the permit, to create a better traffic pattern. It's just an example, and there are probably many others, but I think it's the simplest one to sort of provide. So that's a case where public comments have an impact on what a permit might look like. And there are certainly other cases where we receive public comments that demonstrate that an application really doesn't pass muster, and we deny.
Thank you. My next question is, was in reference to the stormwater management, and I guess there's the 25-year storm sort of standard, and you said that you would change that standard if the standard needed to be changed, and I was wondering if you can change the standard on a pre-existing facility or not.
If a standard was changed, it would have to be done by rule. It would have to go through the rulemaking process in order to do that, and then it would apply to everybody, including existing facilities and future applicants.
So they would have to go ahead and retrofit their facility to meet the new standard?
Well, anything that they did from that point on, they would have to, yes.
So anything that was existing but not, so say they had capped the landfill already and you had a new standard 20 years out that said it needed to meet a 50-year storm, not a 25-year storm or something. No. Would they then have to go back and refit it?
No, they wouldn't. If there was, let's say there was a failure there because of a storm, then they would have to do it to the new standard.
So it only applies to new activity?
Yes.
Okay. And then I was also wondering who was responsible for ongoing monitoring and remediation after the closure, or the sort of if Casella ceases to operate the facility.
The permit lasts forever. The permit actually never doesn't go away because the landfill is there. So whoever holds the permit in the post-closure period is responsible to take care of that landfill.
What happens if that entity no longer exists?
The permit would have to, well, if they no longer exist, then we have financial assurance to do monitoring on the landfill. If be, if they decide to sell that property, then they'd have to transfer the permit to somebody else. And that would be, they'd have to actually submit an application to do that.
Thank you.